Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. We will start our day with Judge Simpson. He is doing probable cause conferences.
Yes. What's gonna So, do we gonna talk about somebody that I hit?
Okay, no, did she tell you whether the case was going to?
Yeah,
Did she say she was going to adjourn it?
no.
Yeah, I think this may be a referral.
Parental.
Yeah, sure, and I'm trying to,
She told me that I'm here about a case about putting my hands on an officer at the correctional facility.
okay.
That's what I'm here for today.
Yeah, Your Honor, we're going to refer this for competency. I'll prepare the competency referral and the, criminal responsibility referral forthwith.
Forensic evaluation is ordered. I'll set a competency hearing for 90.
August 28th.
90? Okay. Say it again.
August 28th.
August 28th, 2025,
Thank you.
9 a.m.
Thank you, Your Honor.
I have a court date August 28th,
Bond will
2025.
continue.
What month is this? June?
This is June, yes.
It comes after June.
Well, I'll come visit you in the back, okay? July comes after June.
Court calls case People versus Charles Tingley.
Your Honor, good morning. Joe Simon on behalf of Mr. Tingley, who should be by Zoom.
Is it?
Tingley?
I am Charles Tingley.
Okay, I'll need a camera.
It's just here.
All right, there he is. Okay.
Your Honor, I'm informed that the long-awaited contract with Detective Babbage in the county has been signed. And we are asking the court to grant our request for another adjournment. We're trying to be one of the first cases in line since we've been waiting, but I can't assure you of that. So,
What's the anticipated time frame?
well,
The only information I have is that I believe the contract has been signed, and so he's gonna start scheduling them.
Got it.
So maybe 3 weeks, if that's.
unfortunately, I'll be gone at that time. So, but
Beautiful. We'll set it then.
thank you, Your Honor. Very kind.
No, I want you around because you're around and Miss Landy's there. We learn things.
We do further our education. That is true.
I'm so full of nothing out. I am. It's a joyous time when you learn things.
It is.
So
That is true.
what date do you want?
Your Honor, could we possibly go to July 10?
Is there any objection from the people? Probable cause conference, July 10, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Yes, I think that's the quietest Landy's ever been. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Molly Fox.
Ellen Dennis appearing on behalf of Molly Fox.
Oh. No. Your name?
Molly Fox.
All right, what are we doing?
Well, Your Honor, this is a PCC conference, and we've had many adjournments, but what I would like to see happen today is that the court would reinstate Ms. Fox's bond and let her get out. And I would say that Jacob Kennedy and I have had many discussions about resolution here, but we haven't really come to a conclusion. And he sent me the paperwork on the recovery court, which I discussed with Molly Fox. I went to visit her on Sunday and talked to her about it. And we went through some of the responsibilities and what would be expected of her if she was accepted in such a court. I believe that she could do that, but only if she has strong family support. So I urged her to, what I would like is for her to get out so that she can talk to the family members, which are, in my opinion, their involvement and support is absolutely essential for her to be able to complete the recovery court program. The other matter is we have never really come to a conclusion as to what the plea would be if she were to go into the recovery court. So I would like to have an adjournment of the PCC, but I also would like to have her released again on bond so that she can do these things and come to some kind of conclusion.
Well,
I thought he
gotta
was,
stop using cocaine.
well, of course she does. Absolutely. And she, she did complete the first 8 weeks successfully of the Dawn Farm program. She doesn't, that's the other thing. She doesn't know whether they would let her back into the program or
They should
let her.
actually be able to re-enroll.
Okay, so what do you want me to do with, you want this adjourned?
Well, yes, but I wanted to be adjourned with a release of her from custody and go back on the bond if possible. Because she's had
Okay,
kind of,
I don't negotiate that way, but that's okay. I don't know that I'll release her. I don't know what you want me to do.
well, as I did make out an adjournment paper.
Do people have a position on bond?
Yes, Your Honor. At this case, involved a situation where the defendant was intoxicated. That's why she failed the test. And then while she was on, I don't think that a release is appropriate without a rigid substance abuse plan, treatment plan in place, which there is not.
Well, I'm informed that the Dawn Farm program would let her back in. I don't know for sure. I can't represent to the court that that's possible, but she seems to think it is.
I don't know.
And that's a pretty, she was attending AANA once or twice a week. She was doing group program, and she did that for 8 weeks successfully. And then, she had the incident where she used cocaine again.
Well, 2 incidents.
2 incidents, sorry.
Yeah. Probably more because there's a lot of abnormal creatinine. She was using. So the issue from the court standpoint is this. I am not going to release her or change her bond until there's something in place so that she's at least receiving some treatment or something along those lines or some program. It's not going to happen. Give you time to put that in place or to try to figure out what that's going to be. And I'd suggest that you talk with the prosecutor's office and try to work something out that is structured for this individual. So your motion for bond modification is denied. I will adjourn this matter to June 26, 2025, 9 a.m. The bond.
Your Honor, just for my own information, if I were able to determine that the Dawn program would let her back in or let her restart or whatever, would that suffice from the court's point of view?
Here's what I'd suggest. If you were to confirm that type of, that there would be something in place for her treatment, I'd suggest that you get with the prosecutor's office, see if the two of you come to some type of an agreement. Can't, you can file a motion, I'll hear it, or we'll hear it on the 26th. Okay,
Thank you, Your Honor.
thank you. Case, People versus Christopher Gilmore.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Wendy Burnwell standing in for the attorney of record, Kareem Johnson.
Your name, sir?
Christopher Gilmore. Good morning, Your Honor.
Good morning. And you have no objection, Barnwell stepping in?
No, no, sir.
All right. All right, what are we doing?
Your Honor, Mr. Johnson has indicated that he received all discovery and he wishes to set exam dates on both cases. And do all that.
People have the witnesses available on the 17th.
My best, Your Honor.
You said June 17, Judge?
Yes, sir. Yes, ma'am.
When did
Preliminary examination in these matters in person, June 17th, 2025, 9 a.m. That is before Judge Moore.
Permission.
Thanks today. If I can leave.
Your Honor, there's an ongoing discussion because my client wishes, Mr. Johnson's client wishes to have permission to leave the state. However, I'm indicating to him that the court would want that in writing. And the court would want
What's
defense
his
counsel,
purpose for leaving the state?
right?
Your Honor, I'm about to turn a new leaf, Your Honor.
Pardon?
Can't just,
All
the case has to be resolved.
right.
You just want to leave the state?
Yes, I'm tired of getting in trouble. My summer, I don't want to spend my
You don't
summer.
like the great mittens to the north? Go ahead. You just want to leave the state while criminal charges are pending? Probably is not going to happen.
All right, thank you so much.
Yep, okay, great. That's, glad we're,
Can't do it.
thank
I
you.
have a good one. Yep.
That was easy. Court calls the case, People versus Marvin Sullivan.
James Fifelsky appearing on behalf of Mr. Sullivan, who is approaching. Can you state your name for the judge, please?
Marvin Sullivan.
Your Honor, at this time, we will ask the court to set this for preliminary
All
examination.
discoveries complete.
Yes, Your Honor.
People have their witnesses available the 17th.
Is it any way possible to go 1 week to the 24th? And I will represent the court. I understand that Mr. Sullivan has a hearing in front of Judge Conlon on an extradition on the 25th. So I don't think this would be holding him any longer than he on this case than he would be otherwise.
I'll leave it to the court's discretion.
Preliminary examination in person, June 24th, 2025, 9 a.m. before Judge Fresh Hour. Bond continued.
Thank you, Your Honor.
Court does call the case of People versus Alexander, is it Bounds?
Your Honor, Student Attorney Kara Rosengren, under the supervision of APD Stephanie Cannon, on behalf of Mr. Bounds. Mr. Bounds, could you state your name for the court?
Alexander Bounds.
Your Honor, we're requesting that the court set a date for Mr. Bounds' preliminary exam.
All discoveries complete.
Yes.
People have their witnesses available the 17th. Preliminary examination in person, June 17th, 2025, 9 a.m. Actually, that's at 12 noon. That is before me.
Thank you, Your Honor.
Bond continued. Thank you, sir. That's in person.
Yes, sir.
Court does call the case of the People versus Elliot Kazan.
Ashley for the people.
Oh, you're still here.
I return, Your Honor.
Oh. Picking
Joe
up knowledge. I'm sorry.
Joe Simon on behalf of Mr. Kazan. Your Honor.
Your name, sir?
Elliot Kazan.
Thank you.
Your Honor, I may request approach the bench, but I'm a little afraid. The last time we were here, we were about ready to enter a plea. Then we had our bond issue. The people have maintained the offer. My client wants to accept it. But could we approach briefly?
Yes, you can.
Thank you.
It's both you two.
Yeah, that's all.
All right, good morning again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. While he is muted, let's go to Jackson County, Florida. This is Judge Anna Garcia, and she is doing VOPs today, I believe.
Correct, Your Honor, and that was given based on some priors on a score sheet. State reviewed that and determined, given everything, that this was an appropriate resolution.
Okay, fair enough. And so we don't have any concerns there. All right. And are the priors that you're seeing from the score sheet from before 18?
Yeah, so there was an issue with the priors. At first, we had, I think.
I remember that it came from Broward. Yeah.
Correct. We overcharged the score sheet, and then Mr. Owens didn't catch it with his previous attorney. So we, with that, got to this agreement.
All right, fair enough. Mr. Johnson, please raise your right hand. Sir, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Tell me your full name for the record.
Kobe Johnson.
Mr. Johnson, did you hear what your attorney, Mr. Brown, just said about resolving your case?
Yes, ma'am.
Mr. Johnson, is that what you want to do?
Yes, ma'am.
Has anyone promised you anything other than what Mr. Brown said to get you to do this?
No, ma'am.
Is anyone threatening you?
No, ma'am.
All right, I have in front of me a 2-page plea waiver and consent form. This is the first page. This is the second page. Did you sign the document right there on the second page?
Yes, ma'am.
Did you have enough time to review this 2-page plea form before you signed it?
Yes, ma'am.
Have you had enough time to talk to Mr. Brown?
Yes, ma'am.
Are you satisfied with the advice and with the counsel that you have received?
Yes, ma'am.
Do you understand that by entering into this plea, you are choosing to give up your right to go to a trial where the state has to prove that you did what they say you did?
Yes, ma'am.
Yeah, so tell me, do you understand that if you do a plea today, you won't get to go to a trial? Do you understand that?
Yes, ma'am.
Okay, and you're okay with that?
Yes, ma'am.
Do you understand that you won't get to tell me any defenses that you have for these charges? I'm just going to do what Mr. Brown said and impose the sentence that he agreed to.
Yes, ma'am.
Do you also understand that you will only be able to appeal an illegal sentence by me?
Yes, ma'am.
Is this what you want to do?
Yes, ma'am.
All right. Mr. Johnson, I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. Johnson, in Jackson County case number 24 CF 449, I accept your plea of no contest to 1 third-degree felony count of resisting. I will withhold adjudication of guilt. Mr. Johnson, what that means is you will not be a convicted felon as an adult, okay? That is significant. You're 24 years old. You have your whole life ahead of you. I hope to never see you back in this courtroom in this capacity again, because if you're back before me, that means you might have violated your probation, and that withhold of adjudication may not remain, and you may become a convicted felon, which affects your rights to vote, your right to bear arms, all sorts of things. Makes it very difficult to get jobs. It's just not the road you need to go down, okay? So you need to turn away from this.
Yes, ma'am.
All right, I see that you have family here in the courtroom. I am sure that they're wanting to help and support you. And so I hope you do better, okay? Mr. Johnson, I'm right now withholding adjudication of guilt. But if I see you again, that doesn't mean that's what's going to stick, okay? I order you to serve 5 years state probation. During that time, I order you to pay court costs, fines, and fees. Is that $1,452? How much? $1,065. I order you to undergo a drug and alcohol evaluation. If that evaluation recommends that you complete drug and alcohol counseling, you are ordered to complete that counseling. It is important that you understand that there will be zero tolerance for the use of drugs or alcohol while you are on probation, and you will be subject to random urinalysis at your own expense. If you test hot, you will go to jail. All right, you understand? All right. I order you to forfeit all items seized and submit to a DNA sample. And as a condition of your probationary supervision for these 5 years, you are not to possess any firearms. Okay? Is there anything further from the state? Anything further from the defense?
No, no, ma'am, Your Honor, we just asked for a payment plan.
Oh, yeah.
Okay.
Yeah. He can pay by the month. He can pay, however, through state probation. Does he pay court costs and fees through state probation as well as there's $20 a month cost of supervision. There's little fees like drug testing fee, like $1 a month, right? Or for the whole 5 years. Yeah. So, there's little fees like that. You've got to pay those through state probation, and you can pay them little by little. They do not have to be paid all at once. Okay. Mr. Johnson, I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Mr. Johnson, I know that you are young. The best thing that you can possibly do is get to know your probation officer very, very well and do everything that they say. And if you are ever unsure about whether or not you are allowed to do something that you want to do, talk to your probation officer and make sure they give you the go-ahead, okay? Step to the side to meet with Miss Sharon Jernigan. She's going to give you some instructions. Mr. Gale?
Does he get extra credit if he takes the basic class course?
Sure, but there was no community service ordered.
Oh, okay.
It wasn't marked.
Wasn't marked, okay.
It wasn't marked, so I didn't order it. But Mr. Johnson, let me tell you this. There is a class. It's 2 hours. It's called Face It, okay? They do it several times a month, and it teaches you how to be successful on probation. I would encourage you. You don't have to, but I would encourage you to take it because it'll just set you up for success, okay? All of us in this room want to see you complete that probation successfully. We would want nothing more, okay? All right. Anything else?
No, Your Honor, thank you. That's all I
Mr.
have.
Brown, always good to see you.
You as well. And thank you to the court for letting us get it all worked out.
Oh, listen, glad to. Happy to have you all here. All right. Okay, Derek, I know you're here. Do I have any other private counsels? So if you want to go, or I can let Guy go, whatever you want, my dear.
We're gonna be a while, go ahead.
It's Guy's show today.
This is my day.
It is. When he's here, he gets priority, so.
I respect.
He taught us all.
He's the legend.
He taught us all.
Your Honor, I have Miss Erin Gillette, case 23-188 CF.
All right, Ms. Gillette, come on up. And I think there is someone on the line also.
Yes, ma'am.
On her behalf.
I filed
Gillette, hello. Hi.
I filed a motion to terminate and modify her conditional release, Your Honor.
All right. What says the state?
Judge, we're objecting. I've had conversations with Ms. Bertia Gillette, who's on Zoom, and also Mr. Derek Gillette, who's in the courtroom today. Based on this conversation, we're objecting to the motion.
I'd like to hear their reasoning and that way I can consider the requested relief and the reasons why there's an objection. So is there anything additional that you want to argue other than what is contained within your motion?
No, ma'am.
All right, fair enough. So that's in writing, it's clear. I'm happy to hear the response and the basis for the objection, or do you wish to take testimony or proffer?
I believe that the Ms. Bertia and Mr. Gillette would like to just address the court and make a statement as to why.
I would like to
that
know
is.
so that I can consider it and understand what the objection is.
Yeah, and I think the defense is going to invoke the rule of sequestration, Your Honor.
You want to?
Yes, ma'am.
Okay, so sir, because you're not on Zoom, I'm going to have you go outside for a minute and we'll bring you back in when it is appropriate, okay? I'm responding to Wade right now.
We figured out what to do.
Perfect. And he just said, what I saw just happened. Okay. All right. So fair enough. So Mr. Gill, can you confirm for me, or Miss Gillette, can you confirm for me that that's Bertia Gillette?
Yes.
All right. Is she in Florida, Mr. Gill?
Yes, she is, Your Honor.
All right. You want me to place her under oath?
Yes, Your Honor.
Miss Bertia Gillette, if you don't mind, please raise your right hand, ma'am. Ma'am, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Excellent. Thank you. Miss Gillette, you can put your hand down. And I know it may be difficult, But if you can almost yell, I promise it doesn't sound weird on our end. And that way we can hear you better, okay?
Okay. Okay.
Can you say something now? That way we can see if we can hear you.
What you want me to say again? Tell me. Oh, speak louder. That's what you want me to do.
Yes, ma'am. That sounds great. Thank you so much.
Okay.
Okay, listen carefully.
Hey, Miss Bertia Gillette, can you hear me?
Yes, I can. Hello.
And could you tell us your name?
I am Bertie Gillette.
Okay. And are you the victim in this case?
Yes. I
And
am.
where are you currently right now?
I'm in my family room in my house.
And what's that address?
2806 Penn Avenue.
Okay. In Marietta, is that right?
That's right.
Okay. And Miss Bertia, you and I have spoken on the phone a few times, haven't we?
Yes, we have.
And your son, Derek Gillette, was also present. Is that right?
Right.
And on those times that we spoke, I spoke to you about the defense motion to modify and terminate the conditional release. Is that correct?
Yes.
And I told you that you would have an opportunity to tell the court how you felt.
Yes.
Okay. Well, now is the time. So you and I have spoken. I know kind of what your position is, but why don't you go ahead and tell the court what you want the court to hear, okay?
Okay. I am Bertie Gillette, and I must speak the truth about how I feel. I didn't know that I would be faced with a granddaughter who would attempt to kill me. And that is what she said. And I was on, I can't get them out of my mind on how all I went through and what I went through. And if you want to, I describe a little of it. And if you don't, it's all right. But I do not want to live in the same time with my granddaughter no more, because I don't know, she might can figure out a way to get in here and complete what she tried to do that very day. So I'm just uncomfortable with her this close to me. And all I could do, I love her, and I don't want to see her hurt, but I don't want to see her hurt me again. And I'll have to say, I do not want her and me to live in the same town ever again. 'Cause I just don't trust her no more. I don't risk her, because if she told me she would kill me, and she really worked hard to do it. And I don't want that feeling ever, ever, ever again, to know that somebody I love and I thought loved me, even when she had, they say she had a mental disability, but that still didn't stop me from wearing the knots and the soul pain. It could happen again. So that's why I'm having my say is that don't let her ever get near around where I live as long as I live.
Okay. Have you had has Miss Gillette, Erin Gillette, had any contact with you since the incident?
No, none whatsoever.
Okay. And it sounds like you're still in fear of Miss Erin Gillette. Is that right?
That's right. I don't know what to look at my granddaughter and see her that day. I never seen her before like that.
Okay.
So I'm just afraid of what could happen the next time, and I want to live my life just like everybody else does.
Yes, ma'am. Is there anything else you would like to tell the court today?
Yes. Y'all do what you see is best, but I am afraid that she's in the same town. And I'll say this, thank you all for letting me speak how I feel what I saw that very day. Every time I think about it, I go shaking and trembling and wondering what could I have done. I don't want to know what I do now because I feel like I've done all I could to show her love. All I want is to thank y'all for your truth about how I feel about me and her living in Mariana together or anywhere
Yes, ma'am.
else.
Thank you.
Don't want
Yes, ma'am.
interfere.
State will tender the witness, Your Honor.
Do you have any questions for this witness, Mr. Blunt?
Just a few.
Go ahead.
Good morning. This is Derek Blunt. Can you hear me?
Mm-hmm.
Yes, ma'am. All right. Prior to this incident happening, was Miss Erin Gillette essentially one of your caretakers? She spent a lot of time taking care of you?
I was at that time doing much of taking care of myself, but she did do trips for me, driving my car to take me to the doctor and a few other little things. She would come by and eat lunch.
And this one incident, which was an unfortunate incident, it was horrible. But this one incident, that's the single incident that ever happened between you and her, right?
No, it was many all during the year. She would snap me off, just give me a hard wondering what's wrong with her.
So she was having mental issues then?
How can I put that? Well, if she would use the car too long, and she would never tell me where she was going or what she was doing with it. And if I said anything to her about it, she would tell me straight out, it's none of my business what she wanted to do. And
Have you and your son, Derek Gillette, talked about this a lot?
not a lot, no.
Has he talked to you recently and been around you when you and Mr. Gill were talking?
When me and Mr. Gill, who is that?
The attorney from the state attorney, the prosecutor?
Oh, he might have been around one of those times, maybe one of them.
And Mr. Gillette is upset about this as much as you are, right?
Well, I guess, I don't know, you can ask him. But I know
Is he your caretaker?
He's the
Is
one
he
that
your caretaker now?
the government is sending people out here to take care of me now. And what little I can't do myself. But he is the head one over getting my doctor's appointments and getting them to them, picking up my medication. And yeah, he's the one to look out for whatever my needs are and supervise them when he can.
Prior to this incident, was he the one that did that?
Yes.
So Miss Erin Gillette didn't do all that stuff for you?
Not a lot, because she stayed angry at me a lot and I didn't know why.
And Derek Gillette, he lives next door to you, or where does he live at?
No, he does not live next door to me.
Where does he live?
And somewhere in Alabama, I can't remember the name. But he was the one that the nurses and everybody contacted him for all my needs. He would call him every trip they made here after they made the trip. They checked out my whatever I might need.
Has the state talked to you about what's called an injunction for protection?
What is that?
Where Miss Erin Gillette would no longer be allowed to be within 500 feet of you, no matter where you are, whether you're in Mariana or whether you're anywhere?
I don't understand. You mean she can stay here as long as she's 500 feet away from me?
She just can't come in contact with you. She can't call you. She can't be around you. She can't come to your house. Has any of that been talked to you about?
I don't think so. I don't remember well, but I don't remember.
So no matter where you're at in Florida, Miss Gillette couldn't come around you.
That is what I wish. I don't trust her. I don't know whether she's angry or intend to hurt me.
Nothing.
Ms. Gillette, may I ask you a question?
Mm-hmm.
What punishment have you discussed that you would like to see happen to Erin? Or are you saying that the system should punish in the manner that we see fit?
I don't know if you can, I don't want to hurt, I don't want to punish rest of her life, but I don't want to with her because I don't know what's on her mind.
Sure. You don't want contact, and that's clear, but let me ask the state. State, what have been the discussions, and is there an offer? I'm curious to know, is the offer prison or is the offer supervision?
No, Your Honor. Ms. Gillette has been declared
Not guilty by reason of consent.
not guilty by reason of consent.
Got it.
We're here for the purpose of the conditional release. that
Got it.
she's on.
Okay. I thought that that might have been where, okay.
I mean, as far as the state's concerned, we're not able to prosecute Ms. Erin Gillette. She's on a mental health conditional release for, I believe, 5 years, and that's kind of what we're.
Until we see if she can be.
Correct.
Rehabilitated. Okay, I'm with you. I forgot about the procedural history of that case. Okay.
Miss Birdie, do you remember me talking to you about the case and going over the case from start to finish?
I think I do.
I talked to you maybe things about like Miss Erin Gillette served 124 days on this charge.
I don't remember you saying it. You could have said it, but I don't.
Okay. Okay. If you never saw Miss Erin Gillette again and she stayed away from you, is that something you would want?
Yes, because I don't know what she's like. She was all them months that I don't know what was wrong with her. It's
Do you
angry
care or I'm sorry, I didn't mean to interrupt you. You just want her to stay away from you. Is that right?
Yes, until I feel comfortable with it, and I'm not right now. I don't know if I ever.
What about a
will.
job?
A
Do you
job?
care if Miss Erin Gillette gets a job? Do you want her to get a job?
Not here where I got to see her passing or something. No, I don't
Okay.
want to have one here.
That's all I have, Judge.
All right. Do you want to have Mr. Gillette come in? What I'm hearing is the defense is willing to stipulate to a permanent injunction for
Absolutely,
protection.
Your Honor.
And I've discussed that with Ms. Berdia and Mr. Derek Gillette.
Got it. And the law with not guilty by reason of insanity is it's got to stay open for 5 years,
It does not have to stay open for 5 years.
but that's what it could, and then you can push it at that point. Okay.
My understanding is it's the court
Mr. Gillette, your understanding is what?
that it's 5 years and then anything else is up to the court's discretion as far as any modifications or termination.
Sure. Mr. Gillette, good morning. Come on up. Why don't you come stand next to Mr. Gill? Mr. Gill, let him stand to your right.
Perfect. Yes.
Thank you. Mr. Gillette, good morning. Sir, if you will, please raise your right hand. Sir, do you solemnly swear or affirm that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right. So, Mr. Gillette, I'm going to let Mr. Gill ask you some questions, but essentially what the court is considering today is whether allowing Ms. Gillette essentially to get gainful employment, return to her home in Mariana, but there's no dispute from anybody involved that she would have no contact with your mother because, and what I'm hearing from the defense counsel is they're willing to agree to a permanent, forever injunction for protection against violence, meaning she couldn't not just have contact with your mother and her home, but if they see each other on the road and she's within 200 feet of her car, she's got to get away from the 200 feet. If they see each other at Walmart and she sees her, Miss Erin Gillette has to leave the facility, that type of thing. She's willing to agree to that. So I want to start as a baseline that everyone here is telling me, everyone agrees there's to be no contact because of what allegedly occurred and to make your mother feel safe. So that's kind of the baseline. And so we're trying to figure out if the court should allow her to return to Mariana under the conditions that she have absolutely no contact with your mother. And I hear that you guys have some concerns and objections, and that's what I need to understand so that I can make the decision ultimately, since there can't be an agreement between the state and the defense. So, Mr. Gill.
Thank you, Mr. Gillette, would you state your name?
Derek Donnell Gillette.
And are you Ms. Bertia Gillette's caretaker?
I am.
You have power of attorney.
I do.
And have we spoken multiple times about this case?
Yes, we've spoken more than twice about the case. Yes.
We met over Zoom when we've spoken about it.
Yes.
We've also met with Ms. Bertia Gillette and we've spoken about the case.
Yes. Conference. Yes.
And at some point, I think my conversations were with you about the defense has made an offer to grant an injunction for the protection of your mother, Ms. Bertia Gillette. And in exchange for that, they would be asking for the case to be dismissed. Did we have conversations about that?
We did.
Okay. And ultimately, after we had all those talks, that's not something that you and I think Ms. Bertia Gillette would be agreeable to. Is that right?
Not totally correct. Yes. Yes.
Not totally. I think
Yes.
at some
Well,
point
there's
it might be
conditional.
close, right?
Oh, yes.
Okay. Ultimately, after that, I told you that this case was set for a hearing today, right?
Correct.
Okay. And I told you you'd have an opportunity to address the court and tell the court exactly how you felt about the motion, which you have a copy, correct?
Correct.
Okay. Well, this is your opportunity, Mr. Jett. Why don't you go ahead and just tell the court exactly what you want the court to hear regarding the defense motion?
Okay. If I might just say this, we're happy to see her and that she's doing better. That overjoys us more than anything else.
Sure.
We're not here to debate was she insane or not. It's not the case. We understand that's the case. I'm here strictly for the reason of protection of my mother.
Sure.
Okay. I feel though that this has been treated as if this is a first time occurrence. To this level, yes, but this is not the first time it's been done. This is what led up to this. And understand as you read a couple of testimonies or something that some of the doctors say as long as she takes some medication, then she's fine. And I think I'm in agreement with that. But that's what led up to this case. She did not take a medication, even when she was urged to do so. She would not take it. In fact, she would get something of an attitude about it. So when they say, well, as long as she take her medication, she'll be fine, which is, I agree, but there's no guarantee of that. And
Sure.
I know you cannot guarantee, the court cannot. It's really going to be more 90% of it is going to be up to her.
Mhm.
The thing is my mother listening? Should she?
Oh, she's here. Yes, she's
Can
listening.
she hear me as well?
Yes.
Okay. My mother had a double mastectomy due to cancer. She is not expected to live for more than a couple of years.
I'm sorry to hear that.
Okay. She's a wonderful mother, but she can be stubborn. My wife and I has asked her to come live with us. I moved closer from Tampa to here after retirement to be closer.
Mm-hmm.
I couldn't live in Mariana due to economic reasons, but we came closer. But she feels with the time that she has remaining that she want to live as secure as possible.
Sure.
As possible. We're not against her having employment. To my understanding, she's employed now. But we prefer her not be in Jackson County to keep her safe and let my mother spend the rest of her life, or whatever's left of it, here at her home, which she prefers. And I've tried in every way we possibly can to get her to move in with me.
Mm-hmm.
But I can understand her decision and
Sure.
what she wants to do. And I try to live by that because I can understand the independence she wants to have. But she still deserves to have that secure feeling. And she feels that if she's near her, it won't happen. A lot of things that I didn't hear discussed in the case about how and what happened during her sanity period, about her getting a tarp and telling her she's going to kill her. I didn't hear all that in the court. That was her plan. I saw the ring recording what happened at that particular time when it was happening. We had, we knew she needed help. And I discussed it with her mother. Her mother wanted me to take guardianship over, but I couldn't because I had my mother to look after it. I try to be as reasonable as I can with it. So we're not trying to prevent her from living her life, but I still think that she should have some type of punishment or penalty to be done, to be paid, due to what has happened. Now I agree, and it seems to be every time I speak to someone says, well, she was insane. I get it. I understand it clearly. And I agree. She shouldn't have any punishment while she was in that state of mind. But the thing that led up to it was not her not taking the medication.
Sure.
But now at this stage, this is where I figure she has to be some type of punishment, some type of penalty for her not doing so, because now she can understand and it'll be impressed upon her what she has done now. Sure, she wouldn't be able to understand during the point when her mind was not right. But now she will fully understand and be impressed by it if she had some penalty, some type of punishment for it.
Sure.
And the thing is, the biggest issue is her not being in Jackson County. It's not having employment. It's not that she hasn't violated any conditions. I'm happy to hear that.
Sure.
And that he says 2 years since the incident. Well, had she taken medication, we wouldn't be here. Just as simple as that. We wouldn't be here. And it's not that the family didn't support her. We were supporting Erin. It's just that, quite frankly, she wouldn't listen.
Okay.
So I'm at the stage to where I want to do what my mother wants to do with whatever life she has left remaining. And that is her wish. Really, that's basically the only wish. It's just whatever she decides to do, how she wants to do it, just not in Jackson County.
Okay.
You don't take any issue with the fact that she was insane at the time of the offense.
I'm sorry, repeat that.
Miss Erin Gillette was deemed to be insane at the time of the offense, and you do agree with that, right?
I agree at the time of the offense, yes. Okay. But my issue still remains. Sure. What led up to it. It didn't have to go that far. We wouldn't have to be here.
Right.
And like I said, I feel still it was treated like that was just the first offense. That's the first recorded offense. It's not counting the times her mother and father had to hold her down in the back seat while they take her to a doctor, or she writing notes of almost suicidal things on her door at her home. See, all these things progressed. And when she was told to take her medication, she refused and got obstinate. Now, when she hears it under these type, I guess, restrictions, it would impress upon her now, because she is well, that when someone says that, it will be terms of endearment to prevent her from this happening ever again.
Sure. Mr. Blunt may have some questions for you, so listen carefully. No questions?
No.
All right.
No, ma'am.
Then Mr. Gillette, thank you for being here. Have a seat. I'm going to make my decision. And is there any further argument? Here's what I want to know from the defense.
Yes, ma'am.
So she owns a home in Mariana, not in the same block or miles of the victim, correct?
Correct.
Why Mariana and not, because she's been for a couple of years now in Central Florida.
She had, she stayed in Tampa.
I remember the gentleman came,
Yes,
former
ma'am.
preacher, maybe?
That's her uncle. They
Yeah.
were both former school teachers.
Okay.
And then the court did allow her to stay in Havana with her mother, who's here now.
Okay. Hey, Mom.
But she has a house that her father, I believe Mr. Gillette's brother, who is deceased now, she had that house here. Her whole life was here. She was employed with Jackson Hospital, working, monitoring the heart monitors at the time of this incident when she had the psychotic episode. And essentially, there is a house here that is sitting that she's not able to rent. She hadn't really even been able to do anything to that house since the time of the incident. So it is just sat there.
Mhm.
But she would like to come back here to Mariana because this is home.
Is Ms. Gillette employed right now?
She is not, because this has been, every time she goes, she understands she would like to work in the capacity she was working prior to this, but
This
because of-
charge doesn't just go away.
it's not going to go away.
Correct.
But because she is on essentially a conditional release for these type of charges, that when she goes and gives an interview, it's pretty debilitating to her getting a job.
But I don't know, and tell me what everyone's experience has been. I don't know that not being on conditional release for these types of charges versus ever having had these charges really makes any difference. For that type of work with the public and other people, I think the fact that these charges exist may be sufficient to, even were she not on release, to prohibit her from having the same type of job that she had before. So what's the plan? Like, where does she want to work if she comes back here? What?
I have no problem with the court inquiring.
Yeah, Ms. Gillette, so raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. So Ms. Gillette, you're living in Havana, okay? Is there, why do you want to move back to Mariana?
My goal is for peace and not to move back to Mariana. Is to leave.
But she wants to finalize.
I have to find out, I would like to relocate permanently in Havana with my mom. But I would have to sell my home, the steps.
She needs to come to Mariana to do some stuff.
You're saying incidental contact with Mariana to finalize the home and then move with her
How
mother?
long that will be. Therefore, I'm moving. Permanent injunction allows her to freely move to do what she needs to do.
So I guess I need to understand what the request is.
We're not getting approval from the court every time she needs to come to Mariana to do something. That's why we're in agreement with a permanent injunction, so she can freely move.
Here's kind of where I am. I like having the criminal charges pending, and here's why. I can put her in jail the second she violates.
If she violates the permanent injunction, Your Honor can put her.
On a violation of injunction, it's a first degree misdemeanor. I got more teeth on a violation of conditional release. So that's kind of where I'm coming from, right? I've got a bigger hammer if she doesn't take her meds, if she has contact with the victim. I've got that bigger hammer and I like it, okay? But I'd have very little issue with her coming to resolve her issues with the house and sell it if her desire is to ultimately live in Havana. If I don't know that down the road, I would have any strong issues with a ultimate dismissal, depending on what the state's position, if this continues to do good. I guess in order to consider a dismissal, I would want to know that really this is stopping her from having a job. I know the charge would, but I don't know that her having on her record versus no longer being under conditional release.
Have you applied for jobs?
Yes, I have.
Have you applied also for disability?
Yes, I have.
Has this came up in any of that, the fact that you have this charge or you are on conditional release?
Yes, sir.
How so?
Has it inhibited you in any of that?
The job was withdrawn because I have charges pending.
What job were you looking for?
At the hospital.
Were they willing to give you the job even if you had this on your record?
This cannot be, if I had nothing pending, yes.
But the fact that you were charged, they were willing to give you the job with the fact that you were charged with this? Because this isn't this is always going to sit on your record, right? I don't know if there's a way to expunge when there's insanity. I mean, you have to have had a null pros. And so I don't know that, but I don't know. I don't know that for a fact. So.
But even then, did you make it that far to know if they would hire you with this?
That is correct.
Okay.
Do what? What'd you say?
I'm saying she didn't make it far enough in the process to know if they would even hire her with this.
I mean, I'd be willing to consider that if I had testimony of someone that
Yes,
would
ma'am.
say, yeah, I'll hire her, even if has these charges from before. We're okay with this. I think the answer to that is no in the healthcare field, but I may be wrong. I'm not a healthcare provider, but that's what I've heard. Okay, so you're telling me you don't want to live in Mariana long-term. You just want to wrap up your affairs, sell your father's house.
That is correct.
Okay. Where do you want to work ultimately?
Anywhere that will hire me.
Sure.
The background check, I just want to clear up something. The background check that was done on me, the hiring agency said that I have charges pending. I have something pending. They didn't know what it was.
Yes.
They didn't know. It was just something pending and I can't have anything. They just really told me, her name is Irameka. She said, you can't have anything pending. You can't have anything pending. So come back to us once this is done, once it's not pending. But I'm gonna work, McDonald's, anywhere, anywhere that will hire me.
Yeah. Okay. So anything else?
Judge, I just would want to make sure that I think the last order, unless there was something that was done on the record that I can't see in the court file, the last order just said no extended visits to Jackson County.
Because I thought there was some discussion about her having to come deal with her home.
I mean, ultimately, if she's coming here for the purpose that's not an extended visit, I don't think that's in violation of currently what is in place, unless there was something else that I missed. So
when we discussed it, it was in relation to like, hey, we can
Sure.
do stuff. We need more. She's asking the court for more than that, and that's why we're throwing out.
What is she? So I know you're asking for taking it off altogether. I don't know that I'm there, but to come to wrap up the affairs of her house, I'm there, right? And if what she's telling me is she wants to live with her mother permanently, I like that, because if she stops taking her meds, mom will tell us, or hopefully mom will call the provider. I can order mom to tell us, or subject to contempt of court, and then we can, address that situation there. I mean, I think we can keep Miss Gillette protected, okay? But I need the hammer. And I'd be willing to consider, well, the state has a basis to object prior to 5 years, right? For a dismissal.
yeah, we're definitely objecting to a dismissal. I think ultimately, based on the reports, the last Grace Point report, Judge, it says it's beneficial for her to continue on mental health conditional release. So we're asking for her to continue on a mental health conditional release. I think it's beneficial, and that's what the reports say. Ultimately, as long as there's a safety plan in place for whatever's going on in Mariana, that's what the state is really asking, is that there be some type of safety plan for when she's here in Mariana. If there's a safety plan in place, I don't see how that's not unreasonable.
Well, I mean, certainly the criminal no contact is leaps and bounds better than an injunction, because it's got more teeth. So I'll allow, look, Mr. Gillette, I know this is not what you want, and Ms. Gillette, I know this is not what you want, but I'll allow you to come to Mariana. I'll allow you to be here for whatever amount of time you need to, clean up your affairs, to try to sell your father's house. If you need to be here for weeks at a time, that's okay. But you may have absolutely no contact with your grandmother or with her family, okay? And that means you may not have any in-person, telephonic, or third-party contact. You've lived by those rules for the last 2 years. I have no doubt that you will continue to live by those rules. But if there's any indication that you have gone to her home, gotten near her, called her, tried to reach her, I will immediately put you in jail and hold you without bond. Do you understand?
Yes.
Okay.
Yeah.
So I will consider whatever else down the road on the conditional release once we have better information about what she can and cannot do with her job situation. But yeah, she can come to Mariana under the circumstances. You've done well. I hope you continue to do well. But you are ordered to continue your mental health therapy. I want to continue to receive updates. And if you do not comply with your mental health therapy, you will be in violation of your court conditional release and you'll be back in jail. Okay, so just know that. But I hope things are going well. I mean, and it sounds like they are. And so keep that up. Mr. Blunt, additional rulings requested. So basically it's, she can come back to Mariana. there's that ability, especially based on the information that she's provided, that she ultimately wants to be in Havana long-term. Mr. Gillette, you had a question? Yes, sir. Loudly, because I can't hear you. It's okay. And there's a really loud air conditioner over here. No, come on up.
So that I clearly understand
Sure.
what you're stating. She's allowed to come back,
Yes.
but there's no, I know previously you said that they requested that she come back and you didn't grant that. I remember when it happened.
Right.
You
It
said because
was
they
kind
didn't
of no
have-
extended visits.
Right. Well, it was none because they couldn't give her, they couldn't give you a time when they come in and take care of the matters and then leave. So
Right.
you said no.
Right.
Okay. In reference to that, I'm trying to understand, are you saying she can come back? Is it
She can
it may
come back
take
and be here.
2-3 years, whatever it may be to,
She can come back as long as she needs. There's no limitation for the amount of time that she can be in Mariana. And the court has made that decision based on how things have gone so far and how she has progressed. But the ruling that she may have no contact with your mother remains. And she remains under this court's jurisdiction on a conditional release. And if there is any, even a minuscule violation of that no contact order, I can immediately put her in jail because she's still under my jurisdiction. But she can be in Mariana. I've considered your objections. I've considered their requests, and that's the decision I've come to. Okay. I understand that that's not what you wanted, but that's your clarification. There's no limitations on her being in Mariana. Okay. Other than she can't contact her mother, obviously.
my grandmother.
Her grandmother, your mother.
Exactly.
Yeah.
Yes.
Okay. Yes, sir. All right. All right. Thank you, guys. Will you get me an order?
Yes, ma'am.
Thank you. Ms. Gillette, thank you very much for being with us.
Your Honor, do we need to docket her to come back at any point or how?
I don't think so. I mean, what do? We just keep it open and then you'll bring it back one day.
As I get documentation from Grace Point, I'll file it, a confidential filing with the court.
I mean, I think, ladies, can we do kind of like a NECOM close? Because of the mental health conditional release, isn't that, talk to Jeannie. It's called NECOM, NECOM, close, and she'll know. And we close the case basically on a mental health conditional release and then whenever. So basically you're until further order of the court under that mental health conditional release, but Derek and you will talk about coming back and then the state will tell us its position if it's years down the road or whatever. Okay, all right.
Okie dokie. One of the things I love about doing this live show every day is you never know what you're going to get. Every day is a surprise, and wasn't expecting to stumble into that hearing, but it was interesting, especially as Michael, I think you pointed out, emotional, kind of like what we had yesterday as well. But speaking of stumbling into things that you don't often see, we're going to head to Detroit because I have had an incredibly rare sighting of Judge Bryant. So let's see what's going on with her today.
But I'm gonna do it now. Let's see. Okay. It won't let me. Hold on. Go back. Okay, here we go. All right, now it's gonna let me be great. Okay, hold on. Oh. All right, this is case number 204552501, the People versus David Mark DeLucia, and the defendant is charged with reckless driving. Today is the date set for review. Ms. Stevenson, your appearance, please.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. David DeLucia. Mr. DeLucia, sir, please say your first, your middle, and your last names.
David Mark DeLucia.
All right. So I'm ready, Ms. Stevenson. Today is the date set for review. Let's see. Look now, I remember him, he remembers me.
Yeah, YouTube star.
Mr.
Last time you got mad at me for saying that.
Right,
I see you,
because
but I see you on YouTube sometimes.
I know, yeah.
You gotta start getting some money from that.
Figure that out. Look, oh, see, they're probably in trouble right now for saying that.
Uh-oh. No, I said it.
I know, but then when I was gonna say figure it out. So yeah, there are some people out there that's getting some money off of it. But
Yeah.
Mr. DeLucia, I remember now, and he was placed on a 12-month probation. I believe we are at the 12 months. Yes, this is the final review date. At some point, I converted some money, and Mr. DeLucia was enrolled in recovery. He has completed all of the terms and conditions of his probation, including paying the court costs. And I'm believing that he's also still in compliance, yes, with his other situation. So, Ms. Stevenson?
So I'm so proud of David DeLucia, Your Honor. I'm so proud of the fact that, you know, he just took whatever he had to deal. He had been getting into trouble a long time. But when I got a text message from him last night, told me that he has come off of parole. I think it is for like the first time in like 25 years or something like that. He's just turned it all the way around. And I'm very happy for him, and I'm very proud of him. I'm gonna miss hearing from Mr. DeLucia. I think I started working his case during COVID.
Yeah.
Remember, like, still being in the basement. I get Mr. DeLucia's stuff together, and he's finally done it. So I'm proud of him, and I'm grateful for him, and I'm grateful to the court for sticking with Mr. DeLucia and helping him to get here. And I think he's going to take everything that he's learned from this court and use it to try to help somebody else get out of some bad situations. So thank you.
DeLucia. Oh my goodness.
I got one more weekend and I'm all done. But then I take an ethics class and I'll be certified.
Mr. DeLucia. And you're off parole?
Yeah. I got discharged in March. First time in 25 years. I haven't been either in prison or on parole. Feels so good.
She was right. And then now I'm on here. My reputation nobody can't say I'm gonna be crying. Then, you know. I'm happy for you, Mr. DeLucia. I'm happy for you.
Thank you.
And I'm excited about your future. So I'm excited that you'll be able to help other people. And when you're finished with this today, this will be your last case. This will be everything you have to clear up.
I'm done. All done.
How you feel? Tell me how you feel.
Oh my God. I can't believe how much my life has changed. I had 17 months clean on the 2nd. That's the longest I've ever been sober out of prison in my life. I turned 60 this year. I just bought a motorcycle.
Uh-oh.
I wanted to show you. I was going to have it on my phone so I could take it outside, but it's on my computer. So I can't.
Oh.
Yeah, it's awesome. I got a loan. I got qualified for no cosigner. My credit union gave me a chance. They said, okay, you have 0 credit. We're going to give you a shot because you're here in the community. And they worked with me. And so I had to come up with a couple grand, which I did. And bought a brand new motorcycle off the lot. First time I ever had a brand new vehicle. I showed you my car last time.
Right.
The white Traverse.
Yes.
It was wintertime.
Right.
We had like 9 feet of snow up here all winter long.
I'm excited for you. I'm excited for you. And your story and your history, I know, is going to be an encouragement, because it's an encouragement to people without your history. So I know that it'll be an encouragement to people who have been in the struggle for a long time, that if you just stay in the struggle, my best friend, who's also a judge, we often say, I mean, we don't want to have to fight and struggle, but the key is to fight and struggle. So if you find yourself in a situation where you have to fight and struggle, just fight and struggle. Don't give up. Don't keep fighting and struggling. So I'm so excited. I feel like a part of our family. I feel like a graduation. I feel like I should be able to have a graduation like the sobriety court have a graduation. This is our own graduation, Mr. Delusion. Congratulations to you. Congratulations. Congratulations. Now, do they have a graduation for the course? They don't have. They just give you a certificate.
Yeah, it's a certificate. It's a certificate. I'll get a certified just from this one, but most employers want you to have the ethics class too. Makes you more employable. I'll probably start out doing volunteer work. I got a proof for disability because I got a lot of shit, a lot of stuff wrong with me. I tore my body up for 40 years. So,
yes.
I'm running on I only sleep for 1 hour a night because I got horrible sleep apnea. Getting that taken care of. All my medical stuff's getting taken care of one day at a time. Can't do it today. I haven't done it yet, but I am doing it every single day. I have so many friends up here that I met through Bear River Recovery.
Right.
I have everywhere I go, I see people I know, whether it's to Walmart or Myers or to the gym. I made a lot of friends in my gym. I just had shoulder surgery on April 25th. I tore my rotator cuff.
Oh.
And so I've been dealing with that. And no, I can't take pain meds. So the surgeon says, "Are you sure you can't? No medication?" I said, "Just Tylenol and Motrin." So, but I've been dealing with it. And
I know that's a tall feat because I had rotator cuff surgery myself.
Yeah.
That's a tall feat, but
after all the pain I've been through, that's nothing.
Right. That's what I was gonna say. You've been through a lot, and your pain tolerance is probably much higher than mine was. But I'm proud of you, Mr. DeLucia, and I hope that I hope that you don't have to meet another judge like this in this way. But I believe the work that you're gonna do, it's gonna put you in contact with people such as myself and such as, Miss Stevenson, but from a different perspective. So this is one of the times where I am excited and proud and happy to discharge you from probation with improvement and close your case out. And I'm looking forward to the work that you're going to do. And look, and had I known you had put some thought into the other outfit, I would have let you keep it on. I would have let you keep it on. So congratulations, Mr. DeLucia, and we will send a copy of the discharge order to you for your records because you're going to be staying up there where you are, right?
This is my home.
Yeah.
I love Detroit. My family's down there and everything, but I'll come to visit. But I found my new home up here. I love it up here.
You turned it around.
I have more friends up here than I ever had back home. I see people wherever I go. It's not a very big town. In the summertime, we get a lot of people up here, but we lose 60% of the population over the winter. It's more of a resort town. I could never afford to live up here if I didn't have a friend like my buddy Jason. I just turned this basement room into my own room. I got the lights on now, but otherwise it's all purple.
Okay.
Looks like I'm living in a nightclub.
Oh my goodness.
I love it.
Well, and we're appreciative of people just like him who, and that's going to be just like you, willing to take a chance on people. And sometimes that's all people need is for somebody to take a chance on them. And so I'm thankful for all the people up there that took a chance on you. And then when people take a chance on you, the way that you return their kindness is to just do right, do well.
Right.
Don't let their chance, go to waste. And I think you've done a great job at that. So congratulations, Mr. DeLucia, and we are dismissing you or discharging you from probation.
That's so
and
awesome.
Good luck to you, okay?
Okay, thank you.
It was great seeing you today. I didn't recognize you at the beginning.
I was waiting to see you. I was waiting to see both of you. So just so we could get this done and I can say what I had to say.
Yes. Well, I'm so excited for you. All right.
Okay. Thank you so much.
You're welcome. Have a great day. Stay safe.
Yes, I will.
Thank you. And take care, Mr. DeLucia.
Okay. Hi, Ms. Stevenson. Thank you.
You're welcome. You're welcome. Thank you.
All right.
Well, that was a good palate cleanser after the previous case. And I mentioned in the chat that I thought I'd seen this guy before. I have. I watched his last hearing. I don't know if that's footage that I still have or if it made its own video, but I've definitely seen him before. And yeah, he has come a long way. So good for him. It's good to see. Let's go to Texas. Let's say good morning to Judge Boyd.
6-3, State versus Jeffrey Guerrero. Can I have parties announced for the record? State.
Andrew Harris, Salem.
Defense.
Scott Sullivan from Mr. Guerrero, Your Honor.
And are you Mr. Guerrero?
Yes, ma'am.
All right. You entered a plea on May 22nd. You waived PSI and TAP evaluation. According to the plea bargaining agreement, punishment is to be assessed at 6 years in the prison. The state is silent on your application, and there's restitution to be determined. And of course, outside the agreement, there's no contact with certain persons. All right, are parties ready to proceed?
I am, Your Honor.
All right, counsel, do you have any witnesses?
No, Your Honor.
All right, the court will hear your argument.
Yes, thank you, Your Honor. Mr. Guerrero is an excellent candidate for deferred adjudication. It will allow the court to, and he'll have to be mindful that any mistake could cost him a lot of prison time. So I think with that over his head, I think he wants to comply with the conditions that this court lays on him. And I think he will do them diligently, Your Honor. And I just think it's the perfect witness for him. Thank you, Your Honor.
All right, Mr. Guerrero, I don't think that probation is appropriate for you. According to the stipulations, this fire was set because you were paid. That's what you told the police.
I didn't tell the police that. It was somebody else who told the police that. That was the other people that told the police that, and at that there was no damage and nobody's pressing charges on.
No, I mean, you started, it says here that you attempted or you started a fire, so that's an arson, and you did it at an apartment complex. Many other people could have been injured.
It was a fence, man.
Okay. All right. Is there anything else?
And
Oh, do you want to testify?
because the video that I had
Would
saw,
you like to testify?
what does that mean?
That I take, have you raise your right hand, swear you in, and you tell me your story. All right, do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jeffrey Guerrero.
All right, so Mr. Guerrero, I want to let you know that if you tell me your story and the state deems that it is untruthful, then even though they made the agreement to remain silent, if there's something that you're untruthful about, they can question you about that. Do you understand? All right, what would you like to say?
I was just saying that
Everyone, please whisper.
from the cause of it, I mean, when I saw the videos, what he showed me, they didn't have no proof of who even did it or what, and then they're pointing the finger at me, and they saw a vehicle, and then from a vehicle, just because it was my ex, they know where I live, they've seen what I do, they see what I do every day, you know, they pass by the house every day. So they're pointing the finger at me because we're stealing my stuff, and they were just trying to get me in trouble for anything, but I haven't associated with these people like in 30 years, and they want to point the finger at me. And from the scene, when I saw the video, they were towing a truck, and you can't even see the license plates. From the license plates, they went to another place. Just by word of mouth, they told them where I live, so they went to my house and ran a plate there at my house, and they came under my name. That's what they told me, and that's how they got proof of saying that that truck was mine. If they didn't read, how could they say it's my truck if they can't read the plates at the apartments?
All right. Any questions?
And
No, Judge.
from the looks of it, there was no damage done to any of it when I saw the videos.
All right. Anything, any
Nothing
questions?
from me,
Jennifer? All right. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money to run concurrent. There's to be restitution, if any, to River Trail Apartments and Orlinda Galvan. There's to be no contact with Orlinda Galvan, Jose Galvan, Sandy Galvan, the River Trail Apartments. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
All right, let's head back to Judge Garcia in Florida.
I don't know if that makes a difference or not.
Yeah, can you hear him okay?
Oh, I can hear him fine.
Okay, great. So listen carefully, Ms. Malone, to what he is about to announce.
All right, so Ms. Malone, just for the record, I came and visited you yesterday. We went over the plea offer the state has made to you, and I answered some additional questions this morning. We have not received that back from you yet, but did you sign that plea form that was sent to you?
I was in the process of doing that just now.
Okay. All right. I think you've got a pen right next to you there. If that is what you're wanting to do based on our discussions, then I would ask you to sign that above where it says defendant. And then, like we talked about earlier, there's also a line underneath that for your age and a line underneath that for your highest level of education, if you could fill those out as well. All right, Ms. Malone, have you signed that plea form?
Yes, sir.
Your Honor, at this time, on behalf of Ms. Malone, we would ask the court to accept this as a plea in absentia. She would be entering a plea waiving her right to a trial. That'd be a plea of no contest to misdemeanor battery. That's a lesser included offense with an adjudication of guilt and the 11 months, 29 days probation. The special conditions would be peaceful contact only with Thaddeus Frankman, and she must complete anger management. And those would be the only special conditions. And unfortunately, I don't have that form. I haven't signed it yet, but we will get that to the court as soon as we can.
What about in the allegations, were the children present during the alleged battery?
They were, Your Honor, yes.
And so is there any provision for contact consistent with Department of Human, whoever the DCF is in Alabama?
We've actually contacted Miss, I think it's Miss Carlisle. We've spoken with her. I think there is an investigation, I believe, based on what we've discussed in Alabama. I don't know what will come of that, but.
So I'm agreeable to accepting this plea, but Ms. Malone, what I would order, in addition to what everyone has agreed to, is for there to be contact consistent with contact allowed through the Department of Children's Services, Human Services. What is it, Raf? DHR. Department of Human Resources. So if there are limitations on contact or contact has to be supervised, then you would have to comply with that as a condition of your supervision. Ms. Malone, well, Mr. Owens, do you have any objection to proceeding and with that consideration and me asking your client if she's okay with it?
We didn't specifically discuss that when we went over the plea offer. Ms. Malone, I never got the indication from you that you were planning to do anything other than what the Department of Human Resources in Alabama has directed you to do. And that's essentially all the court is asking. It just would be that if you were to have any contact that is against the Department of Human Resources plan, and that would also be a violation of your probation. So the question is, knowing that would be a condition of the probation, are you still wanting to enter into this agreement? Or does that change things for you and we can back up and come back to it later?
I've been fully cooperative with the Department of Human Resources in Alabama.
So, Ms. Malone, what I'm saying is I need you to continue to be cooperative. And if they have certain limitations on the contact with your children, I will accept this plea, but I will order that you do whatever they have requested, including as it relates to contact with your children. So if you violate that, okay, all DHR can do is take your kids away. I can put you in jail. So I need to know that you understand that if you agree to this probation and you have contact with your children that is different than what is allowed through DHR, that that's a material violation of your probation. Do you want some time to think about this or no?
No, no.
Okay. Are you agreeable to entering a plea that requires that any contact with your minor children is contact that will be consistent with whatever the DHR has determined?
Yes.
Okay, fair enough. All right. Do you stipulate to a factual basis for purposes of the plea? Is anyone aware of any exculpatory DNA?
No, Your Honor.
All right, and we were at arraignment, so you don't have the benefit of discovery. Is that right? Now, I
Well-
understand that you guys have had some preliminary discovery, but my goodness, you're a human. There's no way you could have really gotten into it between from Tuesday to now, right?
Yeah.
Okay. All right, Miss Malone, please raise your right hand. Ma'am, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Miss Malone, tell me your full name for the record.
Sarah Ann Malone.
Miss Malone, did you hear the announcement that your attorney made? And you can put your hand down. Did you hear the announcement that your attorney made about resolving this case?
Yes, ma'am.
Is this how you choose to proceed?
I do.
Has anyone promised you anything other than what he announced and what I announced to get you to enter into this plea?
No.
Is anyone threatening you?
No.
Have you now had time to review the document and sign the document that is in front of you?
Yes.
Have you had enough time to talk to your attorney?
Yes.
Are you satisfied with the advice and counsel you've received thus far?
Yes.
Miss Malone, you are choosing to take a plea very early in the case. What that means is your attorney hasn't had the opportunity to participate in the entire discovery process. During discovery, he would turn to the state and say to the state, give me all of the evidence that you have against my client. Because Mr. Owens is trained in the law, once he looks at that evidence, he may be able to turn to you and say, listen, I think you have a defense to this case. Because you're taking a plea so early, you are giving up that right for him to be able to do that analysis. Are you sure that's what you want to do?
Yes.
Do you understand that by entering a plea today, you are giving up your right to go to a trial where the state has to prove that you did what they say you did?
Yes.
Do you understand you're giving up your right to present any defenses?
Yes.
And do you understand that you're giving up your right to appeal anything except an illegal sentence?
Yes.
Are you doing this of your own free will?
Yes.
Ms. Malone, I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Ms. Malone, in Jackson County case number 25 CF 195, I accept your plea of no contest to 1 first-degree misdemeanor count of battery. I adjudicate you to be guilty of the offense and sentence you to serve 11 months, 29 days probation through state probation for a misdemeanor offense. During that time, I order you to pay court costs, fines, and fees in the amount of $732.50. I order you to serve 50 hours of community service work If you wish to take the FACEIT class within the next 60 days, I'll give you 10 hours of community service work for a 2-hour class. I order you to pay $20 a month for cost of supervision, submit to a DNA sample, forfeit all items seized. I also order that you may only have peaceful contact with Thaddeus Frankman, and any contact that you have with your minor children must be consistent with the case plan or investigation that's currently in place with the Department of Human Resources in Alabama. Ma'am, do you have any questions for me about the sentence that I have just imposed?
No.
Is there anything further from the state or from the defense?
No, Your Honor.
Ms. Malone, I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Ms. Malone, in a minute, Jones is going to take your fingerprints, but also I need you to listen carefully. Sharon Jernigan is going to give you some instructions. And does she live in Alabama? Oh, will you talk into the mic?
Are you currently living in Alabama?
Yes.
Okay. So mail-in?
She'll have to be on mail-in reporting.
We'll allow it, but do we have to do, I see.
An ICOTS transfer?
Yeah.
No, not on. a
Because of
mail-in.
that.
Because
Okay.
if it was a year, then we would, that would be.
But
an
not
eligible
for that.
misdemeanor, Yes.
Okay.
Can you
Fair
go ahead and
enough.
give me your address, please?
Right now?
Yes, please.
Okay, it's 655 South Kelly, Kelly Street, Slocum, Slocomb, Alabama.
Okay, thank you. So as soon as, upon your release today from the jail, you need to report directly to the probation office, and the jail staff can tell you where it's located.
Okay.
Okay, thank you.
Ma'am, do you have any questions for us?
Am I, like, for the provisions of my probation, I'm going to be completing like the community service and all of this in Alabama, correct?
Yes. If that's what you choose to do.
Okay.
Okay. All right. Good luck to you, ma'am. Mr. Owens, who do you have next?
Your Honor, next is.
Let's head back to Texas and we'll go back to Judge Boyd's courtroom.
I have a digital copy.
Second.
Yes.
What first conversion?
Court is calling 2024 CR 2336 State versus Larietta. Nicole Holmes, could I have parties announced?
Andrew Harris Saleman for the state. John Robertson for Ms. Holmes.
And are you Ms. Holmes?
Yes, ma'am.
Are you the same Larietta Nicole Holmes who was placed on deferred adjudication in 2024 CR 2336 for the offense of injury to an elderly person with bodily injury on June 13, 2024 for a period of 2 years? Is that you? All right, you're gonna have to make sure you keep your voice up so that I can hear and the court reporter can hear. State?
In Bexar County, Texas, the defendant Larietta Nicole Holmes did then and there fail to report to the supervision officer as directed for the months of March and April 2025 in violation of condition number 4.
Are you pleased with that, true or not true? State?
State waives the remaining violation allegations.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
You still want to plead true to violation of condition?
All right, so here's the thing. You're going to have to speak up. And you need to speak the way you speak when you're not in court before me. So whatever agreement you think you've worked out with the state, I don't have to follow that agreement because this is a contract and it's a contract with the court. It's not a contract with the state. It's not a contract with the defense. So you pled true to violation of condition number 4. Regardless of what agreement you think you've reached with the state, I can revoke you and sentence you to 10 years in prison. Do you understand?
Yes, ma'am.
All right, knowing that, do you still wish to proceed with this plea of true?
Yes, ma'am.
All right, is there a proposed agreement?
Yes, Your Honor, to deny the motion, continue on regular supervision and amend for the following conditions. Immediate placement of GPS monitor for 6 months. Proof of residence or proof of employment with every OV. Don't know what OV stands for. If no proof of employment, then proof of disability. If not on disability, 4 job searches per week, as well as minimum of 12 community service hours performed monthly. Immediate enrollment in anger management course. IVR call inline for 4 months. Bi-weekly reporting for 4 months.
All right, so here's my question. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Marietta Holmes.
What have you done since you've been on probation?
Since I've been on probation, I did try to finish my classes.
So you didn't finish your classes, you tried to, all right?
For community service, because last time I was here, my lawyer asked if I could use, I was getting my BA, and he asked if I could use that for community service.
And why didn't you finish that?
A lot in between the time happened, so I did have to drop.
What has happened?
Lights were turned off in November, and it was hard for me to try to get any type of assistance for it because it was overdue and they just turned it off. So in between time, I was trying to find assistance, I was trying to find work, and also trying to maintain my home, and keep up with everything that I could, and also raising my 2 children.
So where are your children now? Who's raising them?
My son, he's with his girlfriend, and my daughter, she's with my sister. She works, my son works. Both of them work, they're both of them in school, and they both get good grades.
Okay. So here's the thing with lights being turned off. Back in the day, people didn't have lights. You turn on a candle. And people always assume that where people are in their station in life is always where they've been. Like they never had financial problems or things haven't. I've had my lights turned off before. And you know what? My mom and my grandmother would always say, hey, whatever you do, make sure that you have if you're living in an apartment, make sure that's paid. If you're living in a house, make sure that paid. If the lights get turned off, if the water gets turned off, at least you'll always have a place to stay. So getting your lights turned off, and sometimes people are like, oh my gosh, that's so embarrassing. It's like, I still have a place to stay. Getting lights turned off happens to everybody. I guarantee you, a majority of the people in this courtroom, attorneys included, deputies included, court reporter included, have at some point had some utility turned off. One time it happened to me, and it's just because I forgot to pay the bill. And I'm like, hey, why is my water not on? And they said, Stephanie Sauce came out and turned it off. I'm like, oh my gosh, I forgot to pay my bill. And they came out and turned it back on, of course. But that's nothing to be embarrassed about. So, and the reason why I'm telling you this story is because you have to reach out to probation and tell them what's going on in your life. Otherwise, you could go to prison for 10 years. Yes. And then who's going to be taking care of your children? Now, what's happening with the new number 1 in this case?
Judge, I can elaborate on that. That is an allegation based on a voicemail that was left with the landlord. I received a copy of the police report. The landlord sent a copy to the court, and that was forwarded to me by Norma. They took a police report based on a voicemail. And last time I looked, a voicemail doesn't arise to a Class C threat.
What?
So anyway, that'll have to be sorted out. I think that's obviously one of the reasons why we're not going on that today.
All right. So what's happening with this number 1?
That's a municipal court problem.
Okay.
So.
All right. Probation. What is your recommendation?
Judge, the court summary, according to the sentence summary, is exactly what Mr. Edelman states.
All right. So why were you not reporting? That's the easiest thing, to pick up the phone.
I was communicating with my probation officer. I was.
Not in March and April.
I was in March and April. I did. I even got kind of scared because he wasn't responding back to me. He never did tell me to come in. Everything that I was going through, far as dealing with the landlord and also dealing with housing, and my life still been not connected. I was communicating with him.
So has she been communicating?
Judge, I can check the notes.
All right.
That's one thing we discussed, Judge, is that communication, however the communication is not a substitute for reporting. And I think Larry understands that.
And my lawyer did make a good recommendation. He said, when, communicating, texting, sometimes it's best for me to go down there. And I didn't know that. To set up an appointment, go down there so I could be seen. And that way it wouldn't be no miscommunications.
Judge. Lots of office visit in the system indicates February 28th and 2025. There was a text message sent out with an appointment scheduled in March. I don't see anything indicating there was a phone call with that to the officer, and the same for April, Judge. There were also system text messages reminding his moms, you need to pay your fees. There's some batch emails that went out for services.
All right. This is her first motion to revoke. I'm going to tell you something I'm going to tell you right now. Number one, when your utilities are disconnected, that's nobody's fault but your own. If my utilities get disconnected because I forgot to pay, that's not their fault. It's not the utility company, it's my fault. Your emergency is not somebody else's priority unless they want to make it their priority. And when you have a landlord and part of your contract with your landlord is you pay rent and you pay utilities, when utilities get cut off, that means that you didn't pay them, or maybe the utility company made a mistake. If the utility company made a mistake, then they will come out and correct it. Now with CPS Energy, if they do that, they can turn it on immediately because they've switched out everybody's meter where they can operate it from in office. But when your utilities are cut off, one thing you do not do is on your own try to cut them back on or tamper with meters or anything of that nature. Do you understand?
I would never do that. I don't want to.
No, okay, here's the thing. Don't say that because that's what's in the police reports and everything. And the other thing is, it is clear from the court, based upon what you're on probation for, that you do have an anger issue. And it appears from the court that you don't know how to address your angers when things don't go your way other than lashing out at other people. That is going to stop. Otherwise, you're looking at 10 years in prison. Then the 10 years in prison, you can try and lash your anger out at other inmates. And you know what's going to end up happening? Somebody at the prison, somebody at the jail is going to be badder than you. And they're going to unleash anger on you. So if you don't want that to happen, then you had better change your ways. And this bullying thing that maybe you're doing with people that are older than you because you're on deferred adjudication for injury to the elderly, that's going to stop. And your landlord says that they're 57 and they have a disability and they're having to deal with you. So if you were living at that property, you don't have to worry about not having lights at that property because the court is no longer going to allow you to live at that property and you're no longer going to be allowed to have contact with her. If you have contact with her, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
See, and I don't know why you're giving me that attitude now. You know what you did to Miss Holmes, that breathing hard. No, that breathing hard thing. Yes, ma'am. Yeah, that's not going to be tolerated here. Do you understand?
Yes, ma'am.
It's time for you to start showing respect to people, whether you think they're worthy of it or not, because your landlord, Whether you think they're worthy of it or not, you need to show respect to them because you're living on their property in their house and they can take that away. Do you understand?
Yes, ma'am.
And you need to start behaving differently so that your children will know the proper way to communicate and it's not through violence. Do you understand?
Yes, ma'am.
All right, so you're going to start completing the conditions of your probation immediately. And when you are released, if you don't start enrolling in these programs and completing them, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right, the court will deny the motion. Alternate amend conditions to the following. Need to get items, you'll need to have someone other than yourself go over there and go with the police escort to retrieve your items. You are not allowed to call her or have third parties call her or have third parties contact her. Other than that one time when that person goes to the location, if you have items there and they need to go there with the police escort. Do you understand?
Yes, ma'am.
You're going to start your anger management classes and probation. What is the earliest she can start anger management?
Give her 30 days.
All right, anger management class are to begin within 30 days. Do you have a disability?
No, ma'am.
All right, she doesn't have a disability, so there needs to be there's no proof of disability needed. You're going to need to get a job. That's how people make it in this world. Nobody's depending on somebody else to pay their bills. You're going to get a job. And if you need to get 2 jobs to make a full-time job, then that's what you're going to need to do. So I'm going to require a full-time job. And for the court, full-time employment means at least 40 hours a week. If you want to get 2 part-time jobs, 20 hours each, that's fine. But you're going to work and there are plenty of places for you to find employment. But sometimes people think certain employment is beneath them. No employment is beneath you because we all need doctors. We all need people who are going to pick the fruit. We all need people who are going to work at HEB or work the fries at McDonald's. There's no shame in that. It's a legitimate job. So proof of full-time employment within 45 days. And GPS, probation, do you want GPS?
Yes, ma'am.
All right, there's to be GPS, waive fees. Do you want full-time GPS tracking? What do you want?
Partial GPS for now.
All right, partial GPS for employment. And GPS is until further notice. And do you still want this IVR hotline?
That part number indicates she's helped submit for UA.
Why are you not going in for your UAs?
To my knowledge, I only felt one that was in.
Why are you missing one? Because when you miss one, you could go to prison for 10 years.
I think the day that I missed that was when I went to the office to see him. And by the time it was time for me to leave to get in my Uber, they were going to be closed. And I think it fell on the weekend.
All right, probation, do you still want the IVR hotline?
Monthly UA.
All right, monthly UAs. You're not to miss a single UA. Do you understand?
Yes, ma'am.
Probation, is there anything else?
The bi-weekly reporting for 4 months, Judge.
All right, bi-weekly reporting for 4 months.
Nothing else, Judge.
Is there anything else you need from the court in order to be successful?
Oh, ma'am.
All right, you better do better. Otherwise, you're looking at going to prison for potentially 10 years. From here on out, we can go off the record, from here on out, anything that you do, you need to ask yourself before you do it, is this something that could result in me potentially going to prison for 10 years? If the answer is yes, don't do it unless you want to potentially go to prison for 10 years. If your answer is, well, maybe it could, don't do it because you could potentially go to prison for 10 years. Do you understand?
Yes.
All right, good luck to you. Thank you, counsel.
You know, Judge talking about how there's all work is like honorable kind of dovetails into what we talked about on the pre-show yesterday, defining yourself less by what you do to get your money, what your job is, and more defining yourself about who you are and what you want to be about. So good words, I think, from the judge. By the way, if you want to join us on the pre-show, all you have to do is be a channel member. There is a link for that in the pinned chat, and we would love to have you there. Let's go back to a court that we first visited last week. We liked them. I love them just for their name alone. This is Judge Andrew Wheeler in Battleground, Washington. Let's see what's going on.
Guilty, the judgment and sentence, and it looks like perhaps an amendment to an infraction on one of the charges. Mr. Callahan, can you hear the court this morning, sir?
Yes, sir.
Okay. Your attorney, Mr. Campbell, was with us on Zoom. Have you had plenty of time to talk to Mr. Campbell about your plea today?
Yes, I have.
Need any additional time before we proceed?
No, sir.
Mr. Campbell, are you proceeding with the plea? I just got your email.
The initial, I would have an initial request on the client's behalf to review release conditions, Judge, and I can explain exactly where we're at and why that would be. So initially, this matter made first appearance, I believe 3 weeks ago. Mr. Callahan had a felony hold, and as such, his trial date was scheduled in July. We rescheduled his next court appearance to July. That felony matter was dismissed. All of the holds in Clark County have been removed, excepting a out-of-county Multnomah felony warrant. So he has to go make appearance on that and deal with that matter. In reviewing the case, Mr. Callahan would have a desire to litigate the theft 3 matter. It's an allegation that he was stealing aluminum cans from recycling receptacles. There is I think, a robust potential defense in these regards. However, he does not have money with which to post bail, and he is not willing, and I don't mean this in a disrespectful way to Mr. Callahan or the court, but it's just, we could schedule trial today as early as possible. I would be willing to schedule it as early as possible. I'm ready to litigate it probably right now, but he doesn't want to wait for that purpose, even in spite of the fact that he has a strong desire to litigate this matter, and there are certain detriments on the theft 3 conviction that he would like to avoid. So on that ground, there's a $500 bail that's posted in this matter. He has had numerous warrants in Clark County and Battleground. I'll be frank with you. I think he's had at least 3 warrants. If I'm not mistaken, I'm not sure if the court paperwork is even prepared for a review of that factor, but he has missed some court hearings. He's got a substance use disorder history. His grandmother lives in Clark County. He can stay with her because of the fact that he is sober currently. When he releases from custody in Multnomah, his plan is to go into inpatient. He understands how to make contact with my office. I think that on those grounds, we would be asking Your Honor to consider removing the bail that's in place at this moment. And I apologize greatly to Ms. Carmody because I only have allowed her notice of about 45 minutes of that fact, because we just spoke about it this morning. So I'm not sure of the city's position, Your Honor, but that's defense request. If the bail is not removed, then the client is very open and wants to change plea today. And so that would be the alternative next step moving forward if bail is not removed, Your
Honor. Your Honor, I think it's a difficult position. I certainly don't want to hold bail over someone to effectuate a plea. The allegations in this case involve recycling material from a bin. I don't have significant community safety concerns. I have concerns about reappearance. So I don't want to put the court in a difficult position, but I guess I would defer to the court on the return to court risk with the bail that's in place. I was chatting while Mr. Campbell was speaking for some of that period, and I don't recall if we still believe that Mr. Callahan would go to Oregon if we released our bail.
I do believe that's the case. The client's only got 4 misdemeanor convictions, maybe 5 now with the most recent resolution in Clark County. He has no felony history. He's being held on a UUMV and possession of stolen motor vehicle allegation out of Multnomah County. I expect, and I can't guarantee this, that he will resolve with being released at some very near point when going back to Multnomah. That's my experience in similar cases. But even if he's in Multnomah County, we can communicate and coordinate as far as making either appearances or scheduling future court dates based on his circumstances.
And as I think through this more, Your Honor, perhaps it would be helpful to let you know that if he pled today, he would be released on our matter because we did offer credit time served. So I guess that probably bodes in favor of defense's request for releasing bail and allowing him to investigate the case. I mean, either way, he's not going to be held on our matter after today.
I think that the concern the court would articulate in looking at Mr. Callahan's criminal history, and I don't know what the disposition on these cases are, and perhaps Mr. Campbell does, but it looks like in November of 2024, when I released Mr. Callahan on pretrial release with the conditions of not to obey the law, that not only did Mr. Callahan get new criminal charges, Mr. Callahan repeatedly got the same criminal charge as I released him on, which was the theft in the 3rd degree. So I understand I'm not trying to manipulate Mr. Callahan in any way, but I think that there is a community safety risk. I don't care what he's stealing. If multiple times I have released him on pretrial release, and multiple times, at least according to my DCH on March 13th, on March 11th, there was 2, well, it looks like to me that there were other theft charges. So no, I think that a $500 bail here is appropriate. Mr. Callahan has every right, if he chooses to set this matter for trial. But no, I'm not going to release him. I think that a $500 bail when someone has multiple times engaged in the same criminal conduct while on release is more than fair and appropriate. So Mr. Campbell, you can talk to Mr. Callahan in a breakout room if you'd like, but no, I'm not going to release him.
And then, Stephen, did you want to speak with me privately, or did you want to move forward with change of plea?
Let's move forward.
We're comfortable moving forward, Your Honor. Mr. Callahan and I had lengthy conversation. I understand his desires and believe he's perfectly capable of voluntarily and knowingly entering a plea today.
All right, Mr. Callahan, the plea form in front of the court says your name is Stephen Wayne Callahan. You are 54 and you've completed college. Is that correct, sir?
Yes, sir.
Are you able to read and understand the English language?
Yes.
In entering a plea to theft in the 3rd degree, you are giving up some important rights that we're going to review on the record. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you. And witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. Do you understand these rights, Mr. Callahan?
Yes, sir.
You understand that in pleading guilty today, you're waiving or giving up those rights?
Yes, I do.
The charge that you are pleading to today is a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. I am told that there is a pretrial agreement. I don't have a copy of it, but I'm sure it's going to be put on the record. It's in the file.
It should have been attached to the guilty plea statement, Your Honor, as Exhibit A. Maybe
So
the
is
very
it the one that Mr. Busby wrote
Mr.
up?
Busby signed.
correct? That is correct.
Yep.
All right. Yeah, just making sure. So there is a pretrial agreement. Mr. Callahan, do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes, sir.
Court can place you on probation for 2 years, during which time you'd pay cost, fees, and assessments as authorized by law. To the charge of theft in the 3rd degree, sir, taking place in the the city of Battle Ground, Washington on November 5th, 2024. How do you plead?
Guilty.
Are you entering the plea freely and voluntarily, sir?
Yes, sir.
Has anyone made any threats or promises to get you to plead guilty?
No, sir.
The factual basis says on or about November 5th, 2024 in the city of Battle Ground, Washington, I did obtain aluminum cans from a refuse bin intending to deprive
Waste control.
Waste Control
Mm,
or Waste Connections LLC. Is that a correct statement, sir?
Yes, sir.
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Campbell.
And Your Honor, we just asked you to impose those conditions as outlined, accepting a 7-day jail sentence as opposed to work crew. I think that's a reasonable resolution in light of the total circumstances surrounding these cases, the client's past criminal history. If Your Honor were so willing and amenable to do so, Mr. Callahan would be released today. I believe he's been in custody for around 27 days. I believe he burned about 10 days of credit for time served on some misdemeanor resolutions to making false statements and theft 3 resolution in 2 separate cases in Clark County. The other matters, I think, haven't been dismissed. And so that's what defense is requesting. He does have the potential ability to earn income in the future. However, he is currently chronically and habitually indigent. Absent him making significant strides in relation to a substance use disorder, which he is going to do. He has a firm desire to do so, and I have strong belief that he can. He is not currently capable of paying fines and fees. I believe he had, let me look here. I believe he was, Mr. Callahan, did you get food stamps at the time of your arrest?
No, sir.
So, I mean, he's got a somewhat complicated financial circumstance, Judge, just surrounding some funds that are in trust that he has to be basically sober for, I think, almost maybe 3 months or something along those lines or greater after going to inpatient treatment in order to be able to access. So he has no current ability to access funds. We just asked Your Honor to find him indigent and maybe do a colloquy if you wish to get further information.
Mr. Callahan, is there anything you'd like to say, sir?
No, sir.
I'll follow the recommendation of the parties. Count 1 on 4A0846765. 364 days in jail with 357 days suspended, leaving 7 days to serve in custody. Credit time served for 7 days. It'll be a $5,000 fine with all 5,000 suspended. I am finding pursuant to Blazina analysis that Mr. Callahan is indigent. Restitution, an amount to be determined to Waste Connections. No law violations, bench probation for 24 months, no contact with Waste Connections. I'm not going to set any future court dates. It looks like pursuant the plea agreement, the cause number 4A0477487 original charge of trip permit violation is being reduced to failure to register a vehicle within 30 days. Mr. Callahan, do you agree that that infraction was committed, sir?
Yes, sir.
There'll be a fine of $145 with a $150 filing fee for total cost of $295. We're going to get you some paperwork, Mr. Callahan. As your attorney, Mr. Campbell, said, it sounds like you will be released or transferred from the Clark County Jail likely today with your credit time served. Thank you for your time today, sir.
Oh, Stephen, it could take him. It could take him a week or 2 to get you from Multnomah. I don't know how long it'll take them, and if they don't come and get you, they should release you. So do you probably have a future date forward on that felony hold? If you do not, then call my office.
Okay, I'll be in touch. Thank you.
All right, let's head back to Judge Boyd's court, and we'll spend some time with her, probably our final hearing of the day.
Record.
Andrew Harris Edelman for the state.
Sam Locke for Christopher Mariscal, ready.
And are you Mr. Mariscal?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mariscal, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
All right, probation, this is an application. Mr. Mariscal, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Mariscal, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you're charged with driving while intoxicated with a child under 15 years old as a state jail felony? Range of punishment is 180 days, up to 2 years in the state jail facility, and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently confident and was legally sane at the time of the offense?
I do.
Mr. Mariscal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $1,500 fine, and the state recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Should be contained in Exhibit 1 and attachments, Judge.
We've reviewed. We have no objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We can, Judge. I prepared him, said there would be a pre-sentence report, but we're happy to waive and proceed to sentencing today.
All right, anything you wish to say on behalf of your client?
He's done fairly well on bond, Your Honor. He had a glitch in February. There was a positive test for alcohol on his ignition interlock the day after Valentine's Day. Nothing that was above the legal limit, but at that time, the court ordered him to do, how many, was 120? 120
Sober meetings, yeah.
And you've done how many at this point? 150. He continued on himself, Judge. He's got, well, there's one other thing I wasn't going to bring it up today, but he's got a travel plan out in October, but we can just address that at some other time. I was going to bring that up at sentencing. I believe he's going to do well on your probation, Judge. He's taking this very seriously.
There's also an alcohol awareness class that you you had me take after the February 14th, which I took immediately as well.
Okay. And what is the plans for October?
He had previously booked a cruise, leaving out of Galveston, going to the Mayan Riviera for his wife's 50th birthday, Your Honor. I told him that we would address that with the court once he'd established that he's a good probationer and that he's not somebody you are worried about.
Well, what I can tell you is I'll allow you to do that. But what I do is upon return, you must do a UA. And what I can tell you, if there are violations for your probation from now until then, don't even bother asking because it's not going to get approved.
That's fine. Yes, ma'am.
All right. The court is going to sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's a $1,500 fine. That will be probated. There's to be 100 hours of community service restitution. I'm going to order that you continue your sober support meetings. So for every sober support meeting you do, that will be 1 hour deducted from your community service restitution.
Yes, ma'am. Yes, Judge.
All right. There's to be the DWI education course.
Yes, Your Honor.
And counsel, if that's been completed within the time frame where this was pending, that will count. All right, there's to be ignition interlock for half the term. Regular reporting by Zoom or in person. Regular random UAs. And for this, I'm going to do the VIP live because this is very serious, okay?
Yes,
With a juvenile in the car and things could have went so badly. And I'm going to do a driver's license suspension for 180 days. Field visits, 1 time per month for 3 months. Probation is, thank you, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And I am going to order parenting classes. And once he completes parenting classes, 50 hours of the community service restitution will be deemed satisfied. Probation, is there anything else he needs? Is there anything else that you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. I know that you understood, or at least now you understand what you did was insane. And I don't mean insane by the legal definition of insanity. I mean insane in that you put your wife's life in danger and your child's life in danger. Your attorney does a lot of DWI cases. I think he can tell you that none of his clients have ever told him, I intended to go out and drink, get intoxicated. Nobody ever intends to get intoxicated. And then for people who end up killing somebody, nobody ever says, you know what, my intention was to go out, get drunk, and kill somebody. But it happens all the time because once you start drinking and you don't know when to stop, and then you drive and nobody can tell you anything because you think you're all right. And then the next thing you know, you're before me, not for just the DWI, but because somebody has been injured or dead. You understand?
Yes, Your Honor.
And that could have easily been your child or your wife.
Yes, Your Honor.
So it appears to the court, you're one of those people who can't drink. I don't drink. I think it's nasty, but that's just me. So you're not allowed to drink while you're on probation. If you drink when you're on probation, that's going to be a violation. So from here on out, anything that you do, you need to ask yourself these questions. Is this something that could potentially result in me going to the state jail facility for 2 years? State jail facility, that's day for day time. So if you were sent for 2 years, you'd be missing 2 years of your family's life. And if you think of everything that's happened in your life in 1 year or 2 years, think about how much you'd be missing. In this court, I want people to be successful in probation. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to the court. If you feel like you're going to pick up a drink, call your probation officer. They're not going to file a motion to revoke. What they're going to do is they're going to send me a notice and say, we need to have a compliance hearing, judge. He's thinking about drinking, and then we'll address it. But if you're just out there doing your own thing, that's not going to help. Okay?
Yes, Your Honor.
Here you go. All right. Good luck to you.
Your Honor.
Yes.
One thing that he may need, in order to successfully complete probation is an occupational driver's license. So I'll just.
Yes.
For it after it's filed.
Yes.
Thank you.
All right. And probation, Mr. Mariscal, he has a trip planned for his wife's 50th. He has a lot of apologizing to do to her. I don't know. Maybe she don't want you on the trip. I don't know. So if you want to slip me a note and his wife really doesn't want him on the trip, she just want to be by herself, just slip that to me and I'll deny the trip. But I've already told him he has the court's permission to go on that trip. But if there are any violations of his probation, he's not going. So whether you're allowed to go is up to you.
Yes, sir.
If you'll give them the October dates, and he's going to need to UA immediately upon return.
Yeah.
Is there anything else you need from the court?
No, Your Honor.
All right, good luck to you, and thank you for always dressing appropriately for court. And I hope the sober meetings are helping you and you're meeting people.
It's helpful. That's why I continue.
All right, awesome. Well, good luck to you, okay?
Thank you, ma'am.
Thank you.
Your Honor. May I be excused?
Yes, thank you.
Judge.
Okie dokie, and that, as they say, is that for today. I hope you all enjoyed it. I know I did. It's been a bit of as a couple of you have pointed out in the chat, it's a bit of an emotional week, though. A lot of tough cases, a lot of mental health kind of stuff, a lot of things that cause you to think about kind of what's going on out there, I suppose, and how people are broken and what we're doing, or in some cases not doing, to really help them. So lots to reflect on here. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. Again, if you're not a channel member, I'd encourage you to give us a try. There's a link in the pinned chat. It's incredibly inexpensive, but one of the things you get is access to the pre-show, where we tend to have fun and it's a little more engaging. We just kind of all let our hair down a little bit. Channel members, though, tomorrow, last Friday, we did an AMA. If you have any questions that weren't able to get asked due to running out of time or something that you thought of, bring that tomorrow, and that's part of what we can do. But again, we'll see you tomorrow. In the meantime, go have yourselves a happy Thursday. Be safe, be happy, take care, God bless.